Assalamualaikum warahmatullahi wabarakatuh. This is our recorded lecture via Zoom on the topic res ipsa loquitur. Basically, it relates to evidential rule in proving negligence. So somehow it still relates to negligence, the previous topics that we discussed. So the outline for the lecture will cover this thing. First, we'll start with the definition of the maxim. And then we are going to look at origins and rationale of the maxim, and followed by the effects or what is the inference of breach. And then another important points are the elements to establish the maxim. And last but not least, the case law, some of the landmark cases on this particular topic. Okay, we go to the definition. Okay, what's the meaning of the word res ipsa loquitur? Obviously, it's not English words. Okay, this is a Latin phrases. So literally, okay, the literal meaning is that res ipsa loquitur means the thing speaks for itself. But the things here is not really the thing that we understand as the plain meaning. Okay, the thing here refers to the facts. Okay, it could be one fact, it could be many facts here. And as far as the maxim is concerned, it's not really a rule or principle of substantive law, but actually it is a rule of evidence. So it relates to evidence, affecting the onus of proof, burden of proof. And it is based on premise on common sense, fair play, and justice. So that's why we need this maxim. We are applying this maxim. And this is the quotation from the judge Harminder Singh in the landmark case David Chalia, the case that we are going to discuss towards the end of the lecture. And then as far as the maxim is concerned, res ipsa loquitur, it is available to the plaintiff. It is to be raised by plaintiff in negligence and nuisance cases. So usually it is used in these two topics, negligence or nuisance. And we want to know the origins of the rule. Okay, so basically the rule originates from this case. The case, meaning that here, this is the case which has established this rule. The case name is Scott and London and St. Catherine Docks Company. Very old case, a classic case reported in 1865. What happened here? So plaintiff, he was a custom officer. So he was injured by some sugar bags. So suddenly, okay, some sugar bags fell onto him, and he was in the defendant's warehouse. Okay, he was doing some of his inspection work, and the judge in this case said that Earl CJ, Chief Justice, the judge said there must be some reasonable evidence of negligence. In a normal case, common case of negligence, plaintiff must provide some reasonable evidence to prove, yeah, this is the negligence happened because of the act of the defendant. But sometimes it's not possible, or it's not always straightforward to do so. So it is stated here, where the thing is shown, okay, the thing here refers to the facts, or specifically for this case, sugar, the falling of the sugar, okay, where the thing is shown to be under the management of the defendant or his servants, and the accident is such as an ordinary cause of things, okay, it does not happen. Normally, it doesn't happen. Normally, we don't expect sugar bags to fall onto you, okay, while you are doing some works here, if those who have the management use proper care. So all this thing, all the things here, facts, incident here, it affords reasonable evidence, okay, in the absence of explanation by defendants. Actually, the accident happened, okay, from want of care, lack of care. So that's how the rule originates. And then before we go to the elements, we want to know, why do we have the rule? Okay, what's the importance? What's the aim of having the rule or the reasons, okay, rationale of the rule? It was provided, or it was discussed by the judge in this case, David Chalia and Monterey, Malaysia, reported in 2009. The ratio is that the basic rule that it is for the plaintiff to prove negligence, and it is not for the defendant to disprove it. So that's basically the methods of proving the case in civil cases. So this rule actually, in some acceptance situation, it may cause hardship, it may cause difficulty to the plaintiff if it is impossible for him to know what precise acts or omission led to this damage. Because sometimes plaintiff cannot really prove how it happened. But whatever it is, there was negligence on the part of the defendant, otherwise it wouldn't happen. And this is most obviously so where the cause of the damage is peculiarly within the means of knowledge of the defendant who caused it. So the rule will be relevant whenever it can be shown that actually the reason of the accident, okay, is within the knowledge of the defendant. Defendant is supposed to know why it happened. So this particular reasoning was also cited actually in the previous case, earlier case, M.A. Clyde and Wong Au Mi, reported in 1970. Okay, now what's the effect of the rule? Okay, if you apply the rule, what happens to the case? Okay, it was discussed in this common law case, Lloyds and West Midlands Gas Board, 1971. The judge was Megao, okay. So it was described that the rule as a common sense approach to the effects of the evidence. So it affects the evidence here, okay. So it means that, okay, this is how it works, okay. It means that the plaintiff prima facie established negligence. So what's the meaning of prima facie? That he as if a plaintiff has proved his part, okay. I mean, which is rebuttable on the part of the defendant later. So whenever there is prima facie case, prima facie evidence, it means the case is sufficient to establish a fact or risk presumption unless the other party, defendant, disprove or rebut. So it's possible. I mean, prima facie is always rebuttable, okay, by producing evidence. So meaning that here, it's not possible for him to prove precisely, okay? Meaning that here we can apply this rule, okay, if it's not possible for the plaintiff to prove precisely what was the relevant act or omission which set in the events leading to the accident. But, okay, the effective cause of the accident was some act or omission of the defendant or of someone for whom defendant was responsible. So it relates, I mean, it is interrelated here. First, plaintiff cannot really provide the evidence, cannot really prove how it happened. And then the cause of the cause of the accident, the cause of the negligence actually falls within the knowledge, okay, within within the responsibility of the defendant. So this particular ratio here was cited by our own. So we follow the approach was cited by Malaysian courts in Teo Guat Loi and Ng Hong Guan, reported in 1998, and also the case that we're going to discuss after this, David Chelia and Monroe Malaysia, reported in 2009. Okay, now we go to the three important elements under res ipsa loquitur. So RIL is the acronym for the purpose of this lecture. Okay, there are three elements altogether. The first one, it must be proved that the thing was under the control of the defendant. We are going to discuss this case, Lembaga Kemajuan Tanah Persekutuan and Mariam. And then the second element, in the ordinary course of business, okay, it does not usually happen unless with negligence. So normally we don't expect things to happen. So we have this case, specific team, consolidated cooperation and Hoon Ui team. And then the third one, okay, the third element, absence or lack of explanation from defendant. So we are going to discuss the case of David Chelia and Monroe after this. So we're going to discuss all the cases one by one. We discussed this case when we discussed the topic of negligence, especially duty of care and breach, I think here. Okay. The case is Lembaga Kemajuan Tanah Persekutuan of Felda and Mariam, 1984. And this is appeal case. So Felda was the appellant and the defendant at the lower court. Okay. Felda engaged a contractor to maintain a land scheme in Pahang. But unknown to Felda, okay, contractor subcontracted the work. And the workers of the subcontractor live in a kongsi house built okay, by either the contractor or subcontractor. That one, there's no direct case to show who actually built the house. Okay, no, they are pushing the facts to one another. And one day the house collapsed and causing death of an employee of the subcontractor. So the deceased dependents, Mariam, okay, sued the contractor, and she sued also subcontractor and Felda. And Felda said, no, we are not liable, okay, because Felda argued that they owed no duty of care, okay, because there's no contractual liability. And then in the course of the judgment, the judge was Saleh Abbas, our former Lord President, okay, Chief Justice. So now he said, this is part of the important judgment here, relevant to our discussion, okay. He said, can Felda now turn around and say it was not liable, okay, to the injured occupant? So in our view, it cannot. Felda cannot say, oh, they are not liable, because although Felda did not build the kongsi house, okay, but it allowed the house to exist, to be erected, and to be used by the wedding laborers. And the works of the laborers here, it benefited Felda. And then the most important part, which is relevant to res ipsa loquitur, is that Felda had control and supervision of the land scheme overall. Okay, and also must make sure that everything was well-being. Okay, was under control. Okay. And then here, okay, Felda owed duty and then Felda breached duty. Okay, Felda did nothing to ensure that the Kongsi house was safe for them to live in. So the court held that eventually okay, the Kongsi house for unknown reasons collapsed, okay, and no proper explanation forthcoming from Felda. So it fits squarely within this principle of res ipsa loquitur. So the court applied res ipsa loquitur and held Felda liable because why the house, Kongsi house, and even the land scheme overall, okay, was under the control and management of Felda, so they cannot deny the liability. And we also have, this is the second case. I mean, this is the elements of in the ordinary course of business. It does not usually happen unless with negligence. So the case is Pacific Tin Consolidated Corporation and Hun Wee Tim, reported in 1967. This case happened those days when one of the important industries of our country was tin mining. But nowadays, I think, it's no longer, we don't have any active mining tin in Malaysia, right? So appellant maintained, this is appeal case, appellant maintained large ponds on their lands for tin dredge mining operations. And they separated each pond with bunds. So they have few large ponds, okay, and there's embankment or bunds between all the ponds here. And the unique part is that the ponds were above ground level. It's not on the flat level or below, it's not the lower lands, basically highlands here. Okay? And water flow from one pond to another by means of spillway. So once one pond is full, then it spills to another pond. And another important or unique part of this case is that the land was located in an inclined valley. So it's not the flat ground level here. Okay? And one day, a large breach in the bund between two large ponds, okay, which together held nearly huge quantity of water, 500 million gallons of water, caused a violent outflow to the lower land. So caused outflow, and this caused extensive damage to life and property to the adjacent lands. So plaintiff and later respondent, they stood appellant for the damage. And this is judgment by federal court. So the court held that the appellant was liable in negligence, and the judge Ong Hot Tai applied the maxim of res ipsa loquitur, and it is stated, it seems self-evident, very obvious, very clear that when one portion gave way, when one pond gave way, while another stood up to strain that affected the whole bund equally, they were not equally stable. So the moment one pond give way, it affects all the ponds. They are no longer stable. So unless the collapse could be traced to some external cause operating on one. So unless the defendant can prove, the flow of the water happened because of some other causes, but they cannot prove it. That's why, they were held liable, the mining owner. Okay, the landmark case for this topic, David Chelia and alias Covil Pillay Chelia, David. So he was suing Monoro Malaysia Technologies in Berhad reported in 2009. The incident happened in 2002. It was reported in a major newspaper. So prior to the opening of the KL monorail, so we have monorail actually nowadays, on 16 August 2002, an accident occurred during a test run. So KL monorail was having some test run. So involving a 13.4 kilo safety wheel. So it's a very heavy wheel here, falling off a train, and hitting the head of a pedestrian walking under the monorail overpass, because monorail is above the normal road, here at Jalan Sultan Ismail. And the victim name was Mr. David Chelia, who brought this case against monorail. And he was a journalist, and he suffered injuries that required hospitalization. So he filed a 5 million negligence suit against the monorail companies because they are the one who involved in the design, installation, and operation. And the suit was also filed against DG, Director General of Railways. So how do you prove the case? Okay, now we focus on burden of proof because in any action for negligence, so it lies on the plaintiff to prove the case by bringing all the evidence. But sometimes it's hard to provide the evidence. So sometimes it's possible, okay, for the court to infer the prima facie inference of negligence. I mean, we just presume there was negligence on the part of the defendant. So we have to apply or utilize the maxim which is known as res ipsa loquitur. So meaning that here it means event speaks for itself, the accident speaks for itself. It essentially a rule of evidence, okay, premise on common sense, so it makes sense, okay, fair play and justice. So based on the facts of the case, okay, this is observation by the court, okay, a safety wheel of a monorail does not, okay, usually it doesn't fall off, okay, on the ground below. And it will also be fair to say that the safety wheel on the train was under the sole control of the defendant. So who controlled the wheel? The operation, the management, okay, of the monorail. So it was under the monorail Malaysia, the company. Okay. And then, although plaintiff could point to the safety wheel coming off the monorail train, but plaintiff himself is unable to state precisely, to explain precisely why the wheel had come off. He doesn't know why it happened, but it happened. The accident happened. There was negligence and he suffered injury. So in that sense, okay, actually plaintiff had made out a prima facie case of negligence on the part of the first and on the part of against the first and second defendant. So now it was therefore incumbent, okay, the first and second defendant is obliged to provide credible evidence, bring in whatever evidence to show that the incident, the accident occurred without negligence. They must rebut the presumption, the inference which is raised on them. So now what a defendant should do? Okay, so inference of negligence can be rebutted by introducing evidence, bring in whatever evidence, okay? And then even though actually the burden of proof remains on the plaintiff, okay, but on the part of defendant, okay, they also have the burden of bringing evidence, okay, producing evidence to explain and show how the incident occurred without negligence, because now we infer there was negligence on your part, otherwise the accident would never happen. So failure on the part of the defendant to do so will establish liability, okay, on their part as a liability for negligence. And then the court referred to the common law case of Moore and R. Fox and Sons, reported in 1956. It was stated, okay, it was held, the onus of proof is not discharged, okay, by merely showing that the accident was inexplicable. You cannot really say to the court, oh, we don't have any explanation. It just happened like that. Okay, so it won't discharge you from the liability of negligence. So to discharge the onus, to be absolved from the burden, okay, of proof here, they had to go further, okay. Either they have to prove that they had not been negligent, or they have to explain. Cannot say, oh, we cannot explain. All right, they have to explain the real cause of the accident, and then meaning that here there's no elements of negligence on their part here. So as far as David Chalia case is concerned here, defendant Monorail Malaysia had failed to provide a reasonable explanation as to how the safety wheel had come off the train. And then they just allude, okay, they just suggest some possibility. Okay, they said, well, maybe there was some tampering, but we are not sure, unknown persons. Okay, but again, there's no evidence of tampering. They just said it is just mere a possibility. Okay, and then and some other reasons also, okay, suggest that, okay, it might also have been that the case that the bolts, okay, the nuts and bolts were not sufficiently tightened, okay, by the employees. That's why the wheel came off, okay, and hit the pedestrian. And in the court's view, the first and second defendant had fallen far short of discharging the honors. So they cannot really discharge the burden which is inferred on them here. So they were found liable. And on the part of the damages, actually it was settled out of court. So the amount actually paid to the plaintiff here wasn't really disclosed. That's part of their arrangement. Okay, but eventually the victim, the plaintiff, won the case. Okay, and then this res ipsa loquitur was being fully applied in this case. That's why this case is one of the landmark case for the topic res ipsa loquitur. I think that's all for this. Yeah, that's all for this topic. Res ipsa loquitur. I stop share. So thanks for listening. So we'll see you in some other topics, inshallah. Assalamualaikum warahmatullahi wabarakatuh.